㗎啦，你頂住先啦。不過。 非常
好各位傳媒朋友好啊！咁我哋香港警方國安處咧係好歡迎今日法庭咧係對黎智英嘅判決嘅。咁咧就3項嘅控罪，分別咧係有兩項嘅串謀勾結外國勢力，同埋1項嘅串謀發布煽動文章，都係罪名成立嘅。嗱，喺呢個長達855頁嘅裁決裏邊咧，咁咧就每一個控罪咧，我哋都見到咧係羅列咗佢相關嘅罪行同埋嘅證據出嚟嘅。咁咧法庭咧亦都咧係指出咗第一被告即係黎智英，佢嘅證供咧係有自相矛盾、前後不一同埋不足為信嘅情況嘅，所以咧法庭咧都喺一個毫無合理疑點之下咧將佢定罪。嗱，回想咧，我哋整個審訊咧係長達156日，其中咧係有52日咧係由第一被告自辯嘅，當中咧我哋嘅證物咧係多達有2222項咁多。我哋喺審訊時候用嘅文件冊嘅個長度咧係超過8萬頁，有14名嘅主要嘅控方證人。其中有5名嘅從犯證人啦，同埋1名嘅特赦證人咧，都係有庭上作過證嘅。我哋從一個數字嚟睇咧，都會見到我哋喺個調查啦，同埋喺一個審訊內咧，都係一個非常浩瀚嘅。我亦都要提一提嘅咧，就係司法機構咧喺每日審訊嘅時候咧，都安排咗400多名嘅旁聽席，係俾一啲公眾人士啦、中外嘅傳媒，包括網媒咧，係嚟旁聽嘅。嗱，呢個咧係確保到我哋整個嘅審訊咧都係公開同埋透明嘅，令到市民大眾可以親身嚟啦，又或者係可以係透過傳媒咧去了解成個嘅審訊，俾我哋知道咧成個審訊係冇任何嘅隱瞞嘅。嗱，除咗咧黎智英3項嘅罪名之外咧，我哋喺個審訊入邊咧，其實咧都透露到一啲嘅事情咧係好值得大家去留意嘅。第一個係關於黎智英喺2019年嘅時候入邊嘅喺嗰個嘅黑暴時候嘅一個角色。嗱，喺第134日嘅審訊時候咧，我記得好清楚，當時咧係黎智英咧作出嘅自辯，而當日嘅討論咧係集中於由李卓人開動其中一個動員當時參加所謂嘅69大人後嘅 WhatsApp group 入邊嘅。黎智英親自承認。係咩咧？就係話佢當時6月8號嘅時候咧，就發布咗一個由李柱銘提議嘅訊息出嚟嘅。佢提議咩嘅咧？就係話希望多啲嘅年青人咧能夠出嚟參與呢一個嘅遊行。係為咩嘅咧？佢希望咧係可以將個畫面咧係能夠突顯到唔同嘅年齡層，尤其是係後生仔咧都係不滿同埋反對香港政府。佢個 WhatsApp 咧睇落去嘅時候咧，李卓人即刻有個回應啦，話俾佢聽個安排係點啦，而且咧亦都呼籲其他人咧繼續去叫多啲後生仔咧係出嚟嘅。嗱，但係其實咧，黎智英咧喺呢類嘅活動入邊咧，不單於此嘅，其實佢喺6月3日嘅時候咧，已經係命令咗當時佢一啲嘅高級員工咧，去盡量去訪問一啲有簽署聯署嘅學生，理由係做咩嘅咧？佢係希望係能夠激發其他嘅學生一齊參加遊行。除此之外咧，當時嘅《蘋果日報》喺黎智英嘅指揮之下，有一啲新嘅嘢係搞出嚟嘅，例如一個叫 Video Talk 嘅 program 啦，又或者係叫做撐學生閱讀計劃，理由都係只係得一個，係策略性咧，係令到煽動多啲嘅年青人咧係投入呢個反政府嘅活動入邊。令人發指嘅咧就係原來黎智英支流嘅人咧，對於年青人嚟講咧，年青人學生嚟講咧，只係一個畫面，係要嚟幫佢咧，係要嚟完成一啲反政府嘅目的。佢都係有子女嘅人啦，為人父母，你見到其他嘅人咧嘅子女係鋃鐺入獄、前途盡毀，我真係唔知佢嘅感受係點嘅。其實好簡單。佢係整個亂局嘅推手，難辭其咎。嗱，第二方面咧，我想同大家分享嘅咧，亦都係喺個審訊入邊見到嘅。 咁咧就係有關於佢嗰個健康嘅狀況。嗱，2022年開始咧，喺一個尤其是喺外地啦，有好多唔同嘅人嘅機構咧，都成日炒作黎智英喺香港係俾人哋虐待，令到個健康狀況係好差。咁咧其實喺2024年9月嘅時候咧，佢嘅代表律師咧亦都有個澄清，有個公開釋咗嚟咧，就係話其實佢係受到一啲適切嘅治療嘅。咁咧包括咗係佢所患嘅糖尿病等等咁。但係咧，呢個嘅公佈咧並冇引起咧佢哋啲人其他咧係有少少收手啊，亦都係繼續去做呢樣嘅抹黑嘢。咁但係咧就個問題就係咧，因為犯人嘅醫療嘅狀況咧係佢嘅私隱嚟嘅，我哋係唔可以隨便去透露嘅。雖然可能係要嚟用作一啲澄清嘅事情，我哋都係唔可以用嘅。但係咧喺今年嘅8月15號嘅時候咧，當啱啱我哋嘅法庭嘅程序咧係去到呢個嘅我哋叫做係一個嘅結案陳詞階段嘅時候咧，曾經有個狀況，佢有一個嘅狀況咧係法庭係需要多啲資訊嘅時候咧係公開咗嘅。咁我好想詳細同大家講下咧，能夠俾大家了解一下，究竟我哋嘅懲教署係點樣去處理一個病人關於一個醫藥上嘅需要。原來當時嘅時候咧，就係咧阿黎智英咧，佢有一個心悸嘅情況，同懲教署講咗，懲教署即刻做咩事情咧？揾一個專家同佢睇，就同佢驗血啊，同佢睇一啲嘅心電圖啊等等嘅嘢。結果睇完出嚟之後咧，發覺正常，但係咧醫生咧仍都係咧建議咧，佢係用一個咧係叫做Holter 呢個咩咧？係一個比較係長時間咧，係可以係要嚟量度佢個心電圖嘅情況，以徹底了解佢個問題。咁啊，除此之外咧，仲要安排咗咧每日啊都同佢量血壓啦，同埋去睇一啲嘅脈搏嘅情況嘅。咁我相信呢啲唔會覺得係一啲虐待人嘅情況嚟㗎，係咪啊？咁所以咧，當時咧我哋嘅法官咧亦都俾咗一個嘅好好嘅一個嘅 comment， 就係話咧懲教署真係好值得去讚賞嘅喺呢方面嘅工作。咁啊，最近咧喺一個禮拜內嘅時間度咧，我發覺咧阿黎智英個女咧亦都加入咗呢一個嘅我哋叫抹黑啊，呢個叫抹黑嘅情況啦嚇。佢講啲咩嘅咧？佢喺外媒入邊咧，佢咧就係講話俾人聽咧，就係佢嗰個嘅父親咧，就係個視力啊越嚟越差啊，聽力啊越嚟越差啊，同埋咧都差唔到行唔到路咁滯㗎啦嚇，要求咧大家要幫佢啊咁。但係個問題就係咧，如果大家都有跟進呢個審訊，今日啦，見唔見到今日嘅情況咧？見唔見到個女有咁嘅情況咧？當然係唔見啦嚇。另外第二嘅咧就係佢亦都咧佢有提出一樣嘢嘅，就係話咧佢喺2024年嘅時候咧曾經接到咧就係懲教署入邊一個福利官叫佢咧唔好嚟啦今日，因為你爸爸嘅身體好差咁樣。但係我哋睇過所有關嘅記錄咧，並冇如此嘅記錄，所以咧我可以喺度講，亦都係一個心懷不軌嘅抹黑行動，係想中傷我哋嘅制度啫嚇。咁啊，最後嘅時候咧，我都想講一講咧，就係一個少少嘅總結咧，就係嗱，我哋睇下黎智英喺成個嘅過程嘅自辯嘅過程之中咧，佢有兩個樣嘅做法嘅，我成日見到。第一，將所有嘢推俾其他人，尤其是佢嘅員工。第二就係利用新聞自由咧，要嚟作一個盾牌。佢成日喺度講嘅，但係結果嘅時候，證據顯示到啲咩出嚟咧？就係等於佢成日講嗰句説話 ：I was the boss。佢先至係老闆，佢係成件事情嘅始作俑者。佢係利用自己嘅傳媒王國去控制個編採嘅方針同埋報導，煽動市民仇恨我哋嘅政府。更加咧係利用自己嘅財富啦，同埋政治人物嘅脈絡，從事一啲嘅勾結外國勢力。總而言之，佢危害國家安全嘅罪行咧係罄竹難書，證據確鑿。I'm going to briefly report my remark about in English. National Security Department welcomed the judgment delivered by the court today, convicting Lai Trial on 2 charges relating to the conspiracy to collude with a foreign country and 1 charge relating to the conspiracy to publish the seditious publications. The court particularly highlighted that the testimony of the Lai is a contradiction, inconsistent and reliable, and also highlighted that he is the mastermind of the three charges. The charges, the trial, which lasts for 156 days, with 52 days being Lai's own testimony. The proceeding involved the examination of the 2,220 exhibits, and the trial bundle used in the court is over 80,000 pages. There are 14 prosecution witnesses, including 5 accomplices and 1 immunity witnesses, have testified at the court. The figures demonstrated the extensive scale and the thoroughness of the both investigation and the judicial process. It's noteworthy that throughout the trial, the judiciary arranged for more than 400 public seats daily, facilitating the attendance of the member of the public and the representative of the both local and the international media, including the online platform. Such arrangement ensure the openness and the transparency of the proceeding, enable the public to observe the judicial process in court or through the media coverage with no element concealment. Beyond the 3 charges for which Lai have been convicted, certain matter revealed during the trial merit our attention. First of all, it's about the involvement of Lai in the social arrest in the 2019. On the trial, on the 134th day of the trial, Lai admitted in the testimony that on the June of the 8th, he had posted a message in the WhatsApp group created by the黎Trial for the purpose of mobilizing participation of the June 6th demonstration that year. In the message, Lai relied on Martin Lee's suggestions to encourage a greater involvement of the young people so that to project a wide range dissatisfaction across the different ages against the Hong Kong SAR governments. His involvement was not limited to what I just mentioned. During the trial, Lai admitted that on the 3rd of June 2019, he had directed his senior staff to interview the student which was assigned for the petitions. In addition, the evidence adduced in the trial established that during the periods of the violence, the Apple Daily, under the direction of the Lai, have launched a number of programs, including one called the Video Talk, and also the support the student subscription scheme, both strategically to attract more young people to participate in the demonstration. In a sense, he is the primary indicators of the violence, unrest, and should shoulder inaccessible responsibility. For another one is about the another point I would like to highlight is the spectaculation of the Lai's health conditions. Since the 2022, a lot of individuals and the group from overseas who have never contacted Lai before, but have fabricated a lot of malicious allegations claiming that he was subject to the human rights and his health was deteriorating, with the appearance that the intention is to discredit the Hong Kong SA government and interfering in the judicial process. In fact, Lai's legal representatives issued a public statement in the September of 2024, clarified that he was receiving appropriate treatment for various conditions, including the diabetes. An image or medical information is his or her own privacy, though we have no privilege to disclose, even though we may use it in the rebuttal fake news. However, how CSD respond towards a Lai medical need, which has been disclosed during the closing submission on the 15th of August, show Lai's health condition and the most important, the manner of a CSD responding to image medical needs. The court was informed that upon Lai complaining the heart palpitation, the CSD promptly arranged him a specialist for the examination. Following having the normal EEG and also the blood test result, the specialist further recommend Lai to have the Holter monitor to undergo a daily monitor of the situation, including the blood pressure measurement and also the pulse by medical staff. Obviously, this is not an inhuman treatment. Even the present judge expressed remarkably in the court that our CSD deserves some prize on this matter. Recently, Lai's daughter, currently out of Hong Kong, has joined in the deliberate dissemination of the false information regarding his health, alleging that his father, healing in the vision, have deteriorating and could only barely walk. But all of you have attended court and see what happened inside. You say that is not the situation which is described by his daughter. And also, she further alleged that in the 2200s, she had received a call from the CSD welfare officers informing her that a scheduled visit was cancelled due to her father's poor health condition. This is no such record to be proved in the CSD, so evidently yet another malicious attempt to mislead and defame. Although Lai sought his testimony to transfer the culpability and to the subordinate and to invoke the concept of the press freedom as a justification, but the totality of the evidence demonstrated that he himself repeatedly admitted that he was the boss. He was the prime master of the offense, which is shown by the evidence. He exploited his media enterprise to manipulate the reporting and inciting the public authorities toward the PRC and the Hong Kong SAR government. Furthermore, through the wealth and the extensive foreign political connections, affiliation, he deeply engaged in the act of the collusion with the foreign power, thereby greatly endangering the national security. In fact, Lai's conviction is justice served. Thank you.
我而家係答嘅時間，所以答嘅地方手同埋佢將嗰兩個講一講自己。
Good afternoon, good morning, Mr. Lee. Some English questions from the SCMP. With the verdict of this case, does this mean that the cases surrounding Apple Daily have officially concluded and that there would be no more further prosecutions? And secondly, with this case attracting heavy international attention, are you worried that this verdict will draw further international sanctions, particularly from US President Donald Trump? Thank you.
Okay. First of all, I think that the legal process is not yet completed. You know that technically the defendant has a right to launch an appeal, first of all, and also some of the confiscation and other processes are ongoing. As for you ask any more prosecution or arrest, I cannot answer you on this occasion because something is ongoing. And the last one about the sanction, I think the question is not to me, but I can answer to you that you can read the judgment and you can see all the things that happen in the court. I think all of that is not afraid of the sanction because we are the one to safeguard the rule of the laws in Hong Kong. Thank you.
阿 Sir 你好啊 ，TV 有兩條問題想問。首先就係咧，今次呢一宗案件咧都係屬於國安法嘅案件啦，咁同樣都係冇陪審團嘅。你覺得到最後會唔會影響到成個審出嘅結果咧？同埋會唔會覺得唔夠公平同埋透明咁樣去處理呢單案件咧？另外就係可唔可以用中文講多一次，即係會唔會擔心今次完咗成個裁決結果之後會引起更多嘅國際關注？唔該。
嗱，首先咁啊，嗱，呢個問題我當然唔能夠預知任何事情啦嚇。如果你話呢一個案件係一個嘅陪審團嘅情況， 但係我想有兩方面咧去回應你呢個情況。第一個咧就係咧係關於陪審團嘅制度。嗱，我哋香港咧係一個普通法嘅地區啦。普通法地區咧其實咧，如果你綜觀嘅話咧，都唔係所有嘅地方咧都係有陪審團嘅出現嘅嚇，並非一定係有嘅。甚至有一啲有陪審團嘅地方咧，佢係一啲嘅特別嘅情況咧，佢都係可以係唔用陪審團嘅。例如英國啦嚇，如果你有留意嘅話咧，英國嘅嗰個嘅 Criminal Justice Act 入邊咧，係有一啲嘅條文咧係容許咧喺啲嘅情況咧係冇陪審團嘅嚇。咁就呢個制度上嘅問題啦。嗱，第二個咧，我想由一個人嘅方面去睇啦嚇。咁陪審團陪審團又好，一個法官又好，其實佢去判一個嘅罪成嘅話，係睇一樣嘢嘅啫，係睇證據，嘅啫嚇。咁咧就如果你問我陪審團同埋一個法官嘅分別係咩咧？法官係一個好專業嘅人士，係不嬲係處理開一啲法律嘅問題嚇。咁另外一個問題就係你嘅一個問題係乜嘢請問？哦，好，係嗱咁樣嘅。咁如果你話究竟是否會憂慮會有另一轉嘅制裁嘅嘢咧？咁呢個問題我絕對答唔到你，你應該係問翻制裁方。但係我只係可以答你我哋在座每一個係負責查案、檢控、審訊，全部都係非常堅定嘅意志，唔會恐懼呢啲嘢嘅。咁呢個咧，我覺得係我唯有可以係講呢樣嘢啫。唔該。
好呢個啲楊學生嘅。
你好啊，香港01，想問下，即係頭先都提到可能遲啲都會有拘捕行動，咁想問下，即係如果即係後續嘅拘捕行動，其實會唔會包括拘捕一啲涉案文章嘅作者咧？同埋想問下，即係如果傳媒想轉載呢啲涉案嘅文章作報導，又會唔會犯法咧？同埋想問，即係見到有聲音都話，即係個判決會唔會影響到新聞自由？想問，即係你點樣睇呢個説法？唔該。
嗱，首先咧就因為調查咧，我哋仲係進行中啦，我唔可以話俾你聽會點樣拘捕啊，或者會檢控啊等嘅嘢啦。咁但係咧就我估有一樣嘢係比較重要嘅咧，就係頭先你講話新聞自由啊。咁頭先咧你都我都介紹過啦嚇，就係話你覺得頭先黎智英嘅行為係咪同新聞自由有關係咧？似乎佢係製造新聞去推動一啲嘅政治目的。咁呢個咧係不容許嘅呢個不容許啦，明顯㗎啦呢個。但係如果你咁樣講法，其實你睇翻我哋嘅國安法入邊第4條講得好清楚嘅，就係話咧，我哋係要保障呢個嘅新聞自由，我哋嘅自由係好緊要嘅直頭有一個條文係寫咗落去，亦都話咧係要根據咩咧？根據我哋嘅基本法啦，同埋根據咗就係我哋呢個嘅國際呢個人IPPC 即係我喺度即係諗一諗下，就係國際公民及政治權利公約，跟嗰個嘅制度去用嘅。我哋呢個係一個好高水準，一個係好高嘅標準嚟㗎嚇。咁但係咧，如果你睇翻入邊咧，佢都有講啊。佢話一個自由咧入邊咧就唔係話完全係一個絕對嘅自由嚟㗎。如果你係牽涉咗國家安全嘅話咧，係需要有一啲嘅制約嘅嚇。咁我希望咧大家都去明白呢一點。
好，最後
答案嘅。Good morning, Mr. Lee. One question from the Hong Kong Free Press. Recently, the international media have been summoned by Beijing's National Security Office over the coverage of the Wangfuk Court fire. Are you concerned that this verdict will cause a chilling effect in the media industry, affecting the ability of the press to report on issues such as the fire?
I have no comment on the first part of the questions about the case you have mentioned. But I would like to reiterate that what we do is quite transparent. You can see that the trial for that is not something about the media. It's totally about a collusion activities with other countries, external power to endanger the national security. It's something about the media, the freedom of the press, nothing about that. he indeed created the news. He used it to accomplish his own political agenda. That's our concern. And okay, thank you.